Welcome back to Educator.com. Today we're going to go over the Bill of Rights, or more specifically the first 5 amendments in the Bill of Rights. There's a lot of information, a lot of court cases, so let's go right down to the material here. All right, and so in today's lesson overview, we're going to review the first 5 freedoms that are found in the Bill of Rights, and these are very significant here. The 5 freedoms listed in the Bill of Rights are the freedom of religion, and it's broken down into 2 different clauses. Freedom of speech, freedom of press, freedom of assembly, and freedom to peaceably assemble. So the 5 freedoms that are found in the first part of the First Amendment here. So there's these 5 freedoms of the First Amendment. So make sure that you're well aware of not only the freedoms, but basically what's inherently meant by that. So what does it mean to have freedom of speech? To what extent? And what are some court cases that you're going to be able to cite? This is particularly useful for the FRQ. Chances are on the multiple choice portion of the exam, you're not going to get too many questions. You may get some questions dealing with what specific court cases that you know or don't know. This actually is very helpful when you're citing different court cases in your FRQ responses, or a question might be whether or not you know this particular court case. So if you happen to have memorized it and you know the general trends of where the Supreme Court has stood on a lot of issues, then you're going to be helpful. So that's why this lecture is going to be very instrumental for you in attacking the free response portion of the government exam. We're also going to, again, briefly review the rest of the rights guaranteed under the other 4 amendments. So remember, we're splitting the Bill of Rights, which is 10 amendments, into 2 separate lectures. So this is part 1 of that lecture. And then, as I mentioned before, we're going to examine key court cases, literally just a handful of court cases, that further clarifies the rights given to the American people as interpreted by the Supreme Court. Okay. All right, the First Amendment, freedom of religion. It's no coincidence that the first right in the First Amendment is the freedom of religion. You had the colonies were actually started by the Puritans coming to what is now the United States. The Puritans came to flee religious persecution. So this idea that the freedom of religion would be established is no coincidence. It's not a coincidence that this is the first freedom that's mentioned under the Constitution, and it's not said as being Congress. It's not saying that individuals have the freedom to worship what they want, and this is a trend in the Bill of Rights. It's what Congress cannot do that is established in the Constitution. Not that you have a right to it, but Congress shall not do this or that. And so this portion of freedom of religion, it's stated as Congress shall make no law respecting an establishment of religion or prohibiting the free speech or free exercise thereof. So again, it's broken down into 2 separate clauses, which is the establishment of religion and also prohibiting the free exercise thereof. So these are two separate concepts that are basically lumped together when you're dealing with freedom of religion. And so let's take a look at these individually here. So you have this establishment clause, and then you have the free exercise clause. So what is exactly the establishment clause? It's pretty simple. According to Thomas Jefferson, there's a wall of separation between church and state. So Congress cannot establish any one religion over another. So the national religion of the United States can't be Buddhism or Hinduism or Christianity or Catholicism. So yes, the majority of Americans would probably identify themselves as Christian, but for the United States of America to say that we are a Christian nation, technically that's incorrect, because the Constitution establishes that the government cannot establish one religion over another. Now, there are a lot of people that may incorrectly say, well, in the Constitution, there's this wall of separation between the church and state, so there should be no religion at all. That's also untrue because it's not in the Constitution. This is just Thomas Jefferson's interpretation that there's this wall of separation between the church and state. If you look at the text here, there's no terminology that says it. Congress shall make no law respecting an establishment of religion or prohibiting the free speech exercise thereof. Is it okay to have religion in the United States? Obviously, yes. And again, the question has changed and has been reframed over the course of two plus centuries on what is permissible and what is not. And you ask one individual, maybe a conservative individual that wants prayer taught in schools, he might have one answer, and you might have a liberal individual that thinks it infringes on the rights of those that don't believe in any religion for religion to be taught in schools. And so you're going to get a variety of opinions on where an individual stands on the Establishment Clause or on freedom of religion. But as far as the Establishment Clause is concerned, all it says is that the government cannot establish a religion. Now, how that's interpreted, again, is going to be different depending on your religious viewpoint or even just your viewpoint of the government's role in religion. The Free Exercise Clause, again, there's another point of contention here. What it says is it guarantees the right to practice any religion or no religion at all. And while absolute, you can theoretically do anything, there are certain practices that may be restricted if in conflict with criminal laws. So free exercise, you can believe anything that you want. So if you believe that this pen that you see right here, if you believe that this is the God of the universe, you are free to believe whatever you want. There's no restriction on thought. So if your religion says that you're going to worship and bow down to this pen, under the Free Exercise Clause of the Constitution, you are absolutely capable of doing that. Now, the trouble comes in is if your religion is going to inflict harm on someone else. So if your religion calls you to throw this pen at police officers, you might come into a problem because that might violate certain laws. And aside from that, that might not be the wisest thing to do. So the Free Exercise Clause, there are going to be some limits. And the court has addressed what is permissible. If your religion, for example, involves using drugs, is that permissible? What about if your religion calls for you to sacrifice animals? Is that permissible? And so these are very intriguing questions on what the limits the government has in establishing a religion and versus allowing you to practice your religion. So those are two fundamental questions. So let's break down the Establishment Clause. This one's pretty fun here. Establishment Clause. There's one court case in particular, but I'm going to mention all four court cases in the beginning so that you can try to associate these court cases when you're dealing with the Establishment Clause. You have Engel versus Vitale, 1962, Lemon versus Kurtzman, 1971, Lee versus Wiseman, 1992, and the Santa Fe School District versus Doe, 2002. So if you're trying to memorize, court cases that deal with Establishment Clause, these four would probably be more than sufficient to know for the AP exam here. So what is Engel versus Vitale? Well, the court ruled that a teacher may not lead a class in prayer even if it is voluntary. So because the reason why is that the public school represents the state and thus violates the First Amendment Establishment Clause. So a teacher, a public high school teacher, a public teacher represents the government according to the Supreme Court. And if a teacher leads a classroom in prayer, then what's going on is that whatever the teacher does is acting as an agent of the school and therefore an agent of the state, and has thereby established religion as being part of the government and thus violating the Establishment Clause. Now, if you ask the Founding Fathers whether or not prayer in school would violate the Establishment Clause in the early 1800s, chances are they would have come up with a different ruling, right? But this is this Engel versus Vitale rule. So even if it's voluntary, even if I were to go in my classroom and say, Class, let's start off in prayer. Dear Jesus, help me to pass, help our class to pass the AP government test. Amen. Technically, I violated the Establishment Clause of the Constitution, even if it's voluntary. Now, if no students complain, then just like anything else, then there's not going to be a problem. But it's one of those things where it violates this, Jefferson's wall of separation of church and state, if you want to call it that. But it's this Establishment Clause that's been violated. One thing that I actually did, this was, I believe, in the 2007 AP exam. When I was teaching my AP government class, I did a quick finals review, and one of the things I try to do, I try to come up with any mnemonics to try to get my students to pass the AP exam. I started off the review session, so this was outside of the classroom. I started off with a prayer, and I prayed to God. God, help us prepare for this AP exam that we're going to take. And I got my students to maybe some students were questioning, why is he praying? Isn't that a violation of church and state? And then I opened my eyes real quickly and I said, according to Engel versus Vitale, I just violated the Constitution right there. And I said, it is vital for you to know Engel versus Vitale. So that was my little corny joke for the review right before the exam. And lo and behold, in the 2007 exam, one of the questions was to explain the court case of Engel versus Vitale, the idea of the violation of the Establishment Clause. So if there's one court case that you want to commit to memory, it might be Engel versus Vitale. So it is vital that you know this. Again, that being said, the probability of Engel versus Vitale, this actually appearing on the FRQ or multiple choice, is probably very low since it's already appeared. But again, if you're doing an essay on the Establishment Clause, then this is the go-to court case that you want to mention. The second one here would be Lemon versus Kurtzman. This law actually struck down a Pennsylvania law basically reimbursing parochial schools, Catholic schools. Basically, what ended up happening was a Catholic school, where they wanted to get reimbursed by the states to hire some teachers, some book supplies, and again, they weren't necessarily promoting religion, so this might have been secular classes, and so they wanted reimbursement from the state. It was granted. There was a lawsuit involved, and the Supreme Court ruled that this was unconstitutional. The reason why it did so is that there's this idea that the government really shouldn't be funding. You're free to exercise whatever religion, but if you do so, then the government really is not involved in that, because by funding it, they're endorsing a particular religion here. And so there's this Lemon test that is still kind of in use today. So any law must have a primarily secular purpose. So the idea is that a law cannot have a religious first purpose. Now, it can be secondary. There can be a secondary reason, but the main purpose of a law has to be secular. The effect must neither promote nor inhibit religion. So the effect is you're not advancing religion, or you're not trying to deny religion from taking hold there. And then this is basically where the Lemon versus Kurtzman failed, is that there must be no excessive entanglement between government and religion. So it was the idea that by having the government reimburse a Catholic school, because the intent was not secular, the purpose of the Catholic school was basically heavily involved in religion, being a Catholic school. The government really had no business reimbursing the expenses of a Catholic school. Okay, some other laws that deal with the Establishment Clause is Lee versus Wiseman. This basically established that no clergy led prayer. So any graduation prayers, if it was student led, is that okay? That was ruled as being okay, but clergy actually, praying at graduation, that was ruled to be unconstitutional. However, no school-led prayers at football games. So Santa Fe School District versus Doe established that even students leading prayers at football games, that would be deemed unconstitutional. Now, again, this being said, are there times where maybe clergy have led prayer at graduation and no one complains? Yeah, absolutely the case, right? So these cases really only come up if there's complaints as to whether or not they want this or not. So even though things may seem unconstitutional in regards to religion, it really depends on maybe a certain section, geography of the United States, where it might be more of a Bible belt, and prayer is more part of the culture, and so it may be violating the Constitution, but no one's going to make a fuss about it. Whereas maybe in some other states, someone makes a ruckus about it, and there's differences of opinion regarding the role of religion in the classroom. The free exercise clause. So again, the free exercise clause, the three court cases that are good to associate is Reynolds versus the United States, and that was in 1879. So this is a late 19th century Supreme Court decision that's still generally held up today. Wisconsin versus Yoder, this is 1972. And more recently, Oregon versus Smith in 1990. Okay, so you might want to associate these particular court cases when you're dealing with the free exercise clause of the First Amendment's right to freedom of religion here. So Reynolds versus the United States. So what is this here? This has to do with a group of the Church of Latter-day Saints. It's more of a break-off of the Mormon Church in the 19th century. Basically, the idea of polygamy was outlawed in the United States by this time. And Reynolds argued that it was part of his religion to have multiple wives. And so this was the free exercise of my religion. So how can you, the government, prohibit me from marrying more than one woman here? But the court ruled that polygamy is outlawed even if it infringes upon your religious belief that endorses polygamous practices. So basically, there are limits in how you practice your faith in the United States. So you may believe all you want about polygamy. I mean, you may say polygamy is great. Polygamy, is held to this high standard. And maybe you can, in your mind, enter into polygamous relationships. But under United States law, a marriage is a contract that involves only two individuals. So, and so if you marry another woman, then that contract is somewhat invalidated. And this is something that the Supreme Court ruled in 1879. The idea that multiple wives would be not supported under religious pretense. The idea that your religion endorses polygamy, and therefore I will be able to marry different women. So that practice was actually outlawed. Wisconsin versus Yoder. This was in 1972. This was the idea that the Amish had the right to keep their students from public school beyond the 8th grade, as going to high school would go against their religious beliefs. So the Supreme Court actually they sided with Yoder here, and they basically said that a basic education was required for these students, and they said that if they don't want their kids attending public school after the 8th grade due to their religion, then this was absolutely okay. So this was a victory for religious liberty, whereas polygamy is outlawed. Withholding your kids from attending high school due to religious belief, that was allowed. Now, can you withhold first grade education from your children as a result? Technically, no. I mean, you can't. I mean, you can homeschool your kid definitely, but to not provide any sort of education at the first grade level, this applied to 8th grade. Now, why 8th grade and why not 7th grade? I'm not part of the Supreme Court, and I'm not one to make the call there. But there are restrictions on this free exercise clause. But there is a lot of liberty in how you actually carry out your faith in the United States. Oregon versus Smith. Oregon versus Smith. The ruling here was that the state of Oregon could deny unemployment benefits to worker fired for using drugs. In this case, it was peyote, as part of a religious practice here. Now, again, interesting that the Supreme Court didn't rule that the worker who was using drugs was not permitted to use drugs during this religious ceremony. Rather, it was that the state had the right to deny benefits for someone fired as a result of using drugs. So notice that the Supreme Court isn't saying that this individual wasn't able to use drugs. It's that if you do, then there's going to be consequences associated with that. So this is kind of one of those things where the government wanted to give the government a certain right without really, without giving them absolute control in terms of how one practices his or her religion. So the idea of using unemployment benefits is absolutely within the realm of a state's rights if a worker is fired for using drugs. So that's again a win more for those that think the government really should kind of have a say in how religion is regulated, so to speak. And finally, one of the things to understand is that the government cannot unfairly target certain religions by passing laws banning practices such as animal sacrifice. So if, for example, there is a local religious group that kills chickens, okay, how awful would that be? They kill chickens. The government cannot pass a law targeting the banning of killing chickens, because that would unfairly target a religious group. So to create a law just to target one particular religion or group, that would be deemed unconstitutional. Freedom of speech. So this is just the second freedom found in the First Amendment. This is a big one. Again, this is something that maybe in the United States, people maybe take this for granted. In a lot of countries, this freedom of speech is a lot. Maybe there is some measure of freedom of speech, but it's a lot less. The freedom is a lot less broad than what is found in the United States here. So a little background on this here. In 1798, under John Adams's presidency, Congress passed the Alien and Sedition Acts, making it a crime to say anything false and scandalous statements against the government. What is false and scandalous? Again, this was meant to prevent people from saying anything that would make the government look bad in light of all the things that were going on, and so a lot of people after this law was not put into effect anymore, a lot of people thought that, this is not going to necessarily come up again, but it did end up coming up. It did end up coming up because in 1919, a famous court case, Schenck versus the United States in 1919, it established this clear and present danger precedent of saying that inflammatory speech was not protected, even though Schenck peacefully protested the draft. And very, very famous fire example in the crowded theater was given to give the idea that there could be restrictions on freedom of speech. So the example that the Supreme Court justices used was that if you're in a crowded theater and you yell fire when there is no fire, and as a result someone is trampled to death, then you are liable for the death of that person because you falsely yelled out fire. And basically that reasoning was used to say that during war times, during very sensitive times, to protest the government and say false things and distribute propaganda, that is not constitutionally protected. Now the ruling has since been modified, so to speak, but this is a ruling that was given, this idea of a clear and danger precedent saying that inflammatory speech was not protected. So it's something, the amount of freedom in terms of speech has kind of evolved over time. Okay, now in Tinker versus Des Moines, this was ruled in 1969. There are students that were wearing black armbands in protest of the Vietnam War, and that right was protected. The school board, what they tried to do was they tried to create a law prohibiting students from wearing armbands because they had found out that students were planning to protest by wearing armbands. And there's nothing disruptive about it. They weren't going to walk out of the school. They were just going to wear armbands in protest. And they were permitted to do so, even though it was in a school setting. Usually, in school settings, students aren't going to be given as much free speech rights than outside the school context. But in this particular case, there's nothing harmful about wearing an armband in protest. Okay. In Miller versus California, 1973, freedom of speech as applied to what was permitted to be sent over the mail. That was kind of an issue dealing with pornography and what is considered to be acceptable or decent, based on community standards. And basically, this obscenity standard was developed by the Supreme Court. So what's obscene here? So anything that's indecent according to contemporary standards. That's a little bit vague here. What's indecent in 2001 might be absolutely indecent in 1991, but in 1871 is absolutely offensive, but maybe in 2114 is perfectly acceptable, right? So the idea that standards are based on what's contemporary, it leaves it open to a lot of different interpretations. And what's indecent for one area might be perfectly decent for another area. So again, that was kind of vague. Another test was that anything that's offensive sexual behavior by state law would be prohibited. Another good question. What's offensive for John might be perfectly acceptable for Gary, and vice versa. So again, there's still a lot of ambiguity as what's permitted by that. And third, if it lacks any serious literary, artistic, political, or scientific value. Again, how do you know what some person might consider to be absolutely artistic might be considered filth by somebody else? So this is kind of a gray area in terms of freedom of speech. Yes, we do have freedom of speech, but to what extent can we express that? Another freedom, actually, that maybe might not be popular to a lot of Americans was found in Texas versus Johnson, 1989. A form of free speech could be burning the United States flag. So the majority of the Supreme Court said that, however reprehensible, however personally repulsed you might be about someone burning the U.S. flag, the right to actually burn the U.S. flag is permitted. And so whether you like it or not, a person has the right to express his or her displeasure at the government and burn the American flag. So that right has been protected. Now, again, if you burn an American flag in the middle of the street, then there are different laws that you've violated. But the actual burning of an American flag, there's nothing unconstitutional. You'd probably be the most unpopular person in the room if you try to burn a flag, say, in the middle of Dodger Stadium during a baseball game against the Cubs. Some outfielder, maybe Rick Monday, might come and save this burning flag, but you have the constitutional right to burn that flag. You don't have the constitutional right necessarily to go onto the field, but you do have the right to burn the American flag in protest. Okay. The third freedom found in the First Amendment is the freedom of the press. So today, obviously, the press is going to be a little bit different than the press found in the beginning times. But the press today includes newspapers, magazines, radio, television, and the internet. And the four Supreme Court cases that we're going to review here is Neer versus Minnesota, 1931, New York Times versus Sullivan, 1964, New York Times versus the United States, and Hazelwood School District versus Kuhlmeyer in 1988. So what are these court cases and what do they say here? So the idea of prior restraint is prohibited and applied free press protection to states under the Due Process Clause of the 14th Amendment. So you can see that a lot. So if the Supreme Court rules something, meaning that Congress cannot, do certain thing, they're also going to apply it to the states on occasion via the 14th Amendment through the Due Process Clause, meaning that the states cannot infringe on your rights to certain things. So prior restraint prohibited, what that means is that the Congress cannot create a law in anticipation of something that's going to be printed out. They cannot create a law saying, you can't print pictures that are, greater than, 12 inches, and then do that. So any prior restraint is prohibited under this court case here. Another court case is the New York Times versus Sullivan, 1964. This was a case where Sullivan argued that, statements against him, against public officials, is protected even if later proved to be false. So Sullivan claimed that that there was inaccurate statements made by this person, and the New York Times went with the story. Well, the idea is that there's got to be an intent to try to harm an individual, knowingly publish false information in order for there to be a violation here. And so the New York Times argued, we made an honest mistake. And so this idea of printing things, even if you're not necessarily sure, that's been somewhat protected here. So the benefit of the doubt is given to the newspaper through this court case. Now, in New York Times versus the United States, the Supreme Court refused to stop publication of the Pentagon Papers. So this idea of prior restraint, again, is reinforced, that even the government of the United States, in the interest of national security, there are certain things that they can't prevent from going to the press. And that was established in this particular court case. So New York versus Minnesota, New York Times versus Sullivan, New York Times versus the United States, these are all court cases that establish that individuals have the right to print what they want. Again, variations on details of the court case, but that's essentially what's being said here. Now, in Hazelwood School District versus Kuhlmeyer, this is actually a victory for censorship. And so whereas most of the time individuals can freely print what they want, in Hazelwood School District versus Kuhlmeyer, 1988, the school district has the right to restrict content for a legitimate purpose, and freedom of press is much more limited within a school context. So yes, you can print what you want, but in the context of a school newspaper, there could be limits. So the principal can unilaterally claim that there's no pedagogical purpose, this doesn't belong in the school classroom, and it could suspend students. It's not violating First Amendment rights of freedom of press. In this particular case, the school newspaper had reported about a girl who was maybe anonymous but had gone through an abortion. There's some maybe violence that had taken place. And even though the person was not named, the idea that this individual's identity could be revealed, the school determined, or the principal determined that that they didn't want to subject their campus to this type of scrutiny. So the principal decided to pull back the newspaper, and they were ruled to be within the right to be able to restrict certain content from being disseminated to their student body. Okay. Freedom of assembly and petition. There's not a whole lot of court cases that kind of cite this, but there is one court case here with freedom of assembly and petition, and it's DeJong versus Oregon, 1937 here. But basically, the First Amendment, the right to peaceably assemble and to petition the government for a redress of grievances. So these are the last two of the 5 freedoms found in the First Amendment. So in DeJong versus Oregon, it basically established the right of association. So you could group together with different professionals. And basically it used the Due Process Clause of the 14th Amendment, saying that states cannot prevent you from associating with other professionals. There are some restrictions, though. The government may require permits to protest, so especially if there's rules that, or if there's fears that a protest may become unruly, they may require permits to protest. However, also certain restrictions are allowed for facilities if it's worded to exclude all groups. So you can't say, okay, this group cannot use this particular facility. It's got to apply fairly to all different groups. And finally, the police may disperse demonstrations if they become violent or threaten public safety. So if there's a peaceful demonstration with a permit, that's fine. But if there's threat of violence, if there's things going on, the Supreme Court basically has ruled that the government has the right to disperse demonstrations that may be considered unruly. Now, the Second Amendment is kind of interesting. I'll read you two different versions, and you can come to your conclusions as to which one is the better definition. As passed by Congress, so the 2/3 required to get amendment ratified. This was the exact wording here. A well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. That was the version passed by Congress here. Now, this was as ratified by the state. The wording was the same, but the commas now, some commas are there, some commas aren't, and it could theoretically change the entire meaning of the amendment. So, as ratified by the states, a well-regulated militia being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed. Okay, so I think it bears worth repeating side by side again here. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Or, as ratified by the states, a well-regulated militia being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed. So, depending on how you interpret this prefatory clause, can alter whether or not you believe that it's in relation to having a well-regulated militia, and that's why the right to bear arms is necessary, or whether or not the right to bear arms is separate from the right to keep a militia. So that's been kind of interesting. But the court case, the most recent court case that dealt with this right to bear arms has to do with the District of Columbia versus Heller, which was established in 2008. So in a 5-4 decision, the Supreme Court upheld an individual's right in federal enclaves, so not necessarily to the states, but at least in Washington, D.C., to carry firearms. There's a law banning the use of handguns, or it's severely restricted. So any handgun had to be disassembled or a trigger lock, and the Supreme Court found that unconstitutional. They didn't apply it to the states, but it basically kind of upheld the ruling. Now again, the ruling was 5-4. The conservative justices upheld this right, whereas the liberal justices went and they had this dissenting opinion. So there's still not a consensus on what it means for the right to bear arms. So review the 5 freedoms listed in the Bill of Rights. Provision banning handguns within the home struck down as unconstitutional here. So again, this idea of the Bill of Rights here, with the Second Amendment. So you did have these 5 freedoms found, 5 freedoms in the First Amendment, but in the Second Amendment of the Bill of Rights, this provision banning handguns is considered unconstitutional. Okay, so the Third Amendment read like this here. So no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in the time of war, but in a manner prescribed by law. What does this amendment actually mean here? So I think today, not many people I know get a knock from Obama or the government, asking for the use of their house. This is probably not Not a very applicable modern day amendment. It's still there though, so let's review it here. So this amendment passed in response to the 1765 passage of the Quartering Act, in which British soldiers they took over civilian households, and so basically the founding fathers they didn't want the people to be fearful that the government would take over their housing, whether for a temporary period or not. But again, this is the least cited of all the Bill of Rights, and it really was never used as a primary argument in any court case. It's been used kind of as a secondary argument. And so how has it been used? It's been used to argue for the implicit right to privacy, that individuals' homes should be free from agents of the state. So not that the government, the primary idea that the government cannot be quartered in your house without your consent, but the idea is that your home is your own stomping ground, so to speak, and the government has no right to go into your house, and kind of implicitly is that you have your right to privacy, at least within your own home. So that's been kind of used as a secondary argument in some court cases. Now the Fourth Amendment is as follows: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So it's the idea of a warrant. So unreasonable search and seizure. That's probably the operative phrase here: unreasonable searches and seizures. Now, in Mapp versus Ohio, 1961. The Supreme Court overturned Wolf versus Colorado in 1949 via the 14th Amendment, which adheres to the exclusionary rule prohibiting the fruit of the poisonous tree. So if there are two court cases that you can associate with the Fourth Amendment, it would be Mapp versus Ohio and Wolf versus Colorado. Wolf versus Colorado basically said that if you got this fruit from the poisonous tree, meaning that if you got illegally obtained evidence, then it's okay. So no matter how you got it, it was fine, no problem. Well, the Supreme Court reversed itself. Basically, 12 years later, in Mapp versus Ohio, it reversed itself, saying no. If the police they violate your Fourth Amendment right against unreasonable search and seizure, and they come upon evidence that is incriminating against you, then that piece of evidence is not admissible. Now, there are certain rules. If the evidence would have been found anyways, then it might be permissible. If it's an individual that does this, but rather than the police, then that's not necessarily a violation of your Fourth Amendment rights. So there are ways that this unreasonable search and seizure has been somewhat modified in cases where there's honest mistake, etc. But if the police comes to your house with no probable cause, no warrant for arrest, and they find tons of drugs, illegal drugs, it is not admissible because there's no probable cause, and it was just a random search and seizure. So to give you an idea of what lengths individuals will go to, I read in an ESPN article about probable cause gives police officers ability to search without a warrant, but cannot randomly stop cars and search. So, if you're driving along, if a cop just pulls you over and randomly searches your car, then he's in violation of your constitutional rights. However, if there's a strong smell of marijuana in the car, let's say hypothetically the cops pulled over Justin Bieber, and Justin Bieber has bloodshot eyes, there's strong odor of marijuana, slurring his or her speech. Well, then guess what? The cop has probable cause that you're driving under the influence and can pull you over and arrest you based on this and search your car as a result of this. Now, if you're driving completely sober, no breath of alcohol, no suspicion whatsoever, and the cop searches your vehicle and finds open bottles of alcohol, then you could argue that there is an unreasonable search and seizure. taking place here. So the interesting article that I read yesterday was that there's an FSU recruit, Florida State University, top junior college recruit to Florida State University. He was pulled over, and apparently the cop arrested him because rather than having the cop find marijuana inside the car, the student athlete decided to consume, literally eat the marijuana, and was arrested for tampering, destroying evidence. But again, because there's this probable cause, there's no Fourth Amendment right that was violated if the police officer, smelled a strong odor of marijuana. That's probable cause. A search warrant is not needed to search the car. Now, the Fifth Amendment. Fifth Amendment is if you like CSI, if you like legal shows, there's some movies that deal with this Fifth Amendment right, or I plead the Fifth. This is a very popular amendment. I think a lot of individuals from pop culture know what these Fifth Amendment rights are. So I'll read the entire text and we'll go over it here. So, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So that's number one. So there's got to be a grand jury indictment. Except in the cases arising in the land or naval forces, so excludes the military, or in the militia, when in actual service in time of war or public danger. Nor shall there be any person be subject for the same offense to be twice put in jeopardy of life or limb. So this is the second clause, second protection in the Fifth Amendment. Nor shall be compelled in any criminal case to be a witness against himself. Okay, so this is the third, this idea of self-incrimination. So you don't have to testify against yourself. Nor be deprived of life, liberty, or property without due process of law. So this is, again, the fourth major thing, the idea of you're going to get a fair trial, or this is the idea, you get due process. Okay, and then also, nor shall private property be taken for public use without just compensation. So it doesn't say that the government can't take away your property, but if they do, they have this eminent domain, but they have to compensate you with what's fair. Okay, sometimes in practice that might not actually be fair, but they have that right as long as they compensate you. So it boils down to these four freedoms here, as I mentioned: the right to a grand jury, the right against double jeopardy, the right against self-incrimination, and this due process clause, which applies to the federal government. Okay, so right to a grand jury, what does that mean? So it was placed as a safeguard to citizens in the case of an overzealous prosecution. So if you're going to go to trial for murder, the prosecution doesn't have the right, without any evidence, I don't like the way you look, so we're going to try you for murder. There's got to be enough sufficient evidence to take it to trial. And so this right to a grand jury was established as part of this Fifth Amendment. Another right, you have the right against double jeopardy. Okay, so this is a guarantee to a defendant that he will not be prosecuted after an acquittal or a conviction and not be punished multiple times for a crime. There's a movie, if you watch the movie, it's appropriately titled Double Jeopardy, and the female lead of the movie basically is Ashley Judd, if I'm not mistaken. She is falsely convicted of murdering her husband. Well, it turns out her husband had faked his death, and later had come back, and Ashley Judd confronted the husband that she was improperly accused of murdering, and she erroneously claimed that if she killed him, because she had served time for killing him, then she was free from this crime because he was already dead. So if she killed him, then that would violate her right against being prosecuted or punished multiple times for the same crime. In fact, that's not the case. If you kill someone and that murder is proven to be false, then that crime would be overturned. And if you murder that same person, well, these are two separate crimes. So double jeopardy wouldn't apply because they're two separate crimes that are taking place. But for Hollywood Fifth Amendment rights, absolutely, that's great to use. But in reality, these are two separate crimes. The right against self-incrimination. I think every elementary school student probably knows this. The idea of pleading the fifth, and extends outside the courtroom as well. So if you are on trial for a murder and the prosecution asks you, did you commit this murder? Rather than perjure yourself and say no, you can say, I plead the fifth. Or rather than being subjected to the prosecution's questioning, you can refuse to take the stand. So this right against self-incrimination applies in the courtroom, or you don't even have to take the stand. It's incumbent upon the prosecution to prove that you are guilty, okay, because you're innocent, presumed innocent until found guilty. But it also extends outside the courtroom, meaning that in Miranda versus Arizona, the ruling was that any confession taking place without a suspect aware of Miranda rights is inadmissible. So if a criminal confesses to the crime but was not made aware of Miranda rights, technically that is inadmissible. So you might think, well, if you're a criminal and you know you're guilty, then you might, what about a spontaneous confession before the rights are read? What if before the cop has a chance to inform you of the rights, you blurt out, oh, I did it, I'm guilty of the crime? Then technically the Supreme Court has ruled that, no reasonable time was given for a police officer to read the rights, and so that might actually be admissible or not. So again, the Constitution, the trend is to give victims or suspects rights. So the burden is on the prosecution to find an individual guilty of a crime, and there are a lot of rights that are given to a victim. So that's been the trend of the 20th century. And kind of a big part is that the due process clause applies to the federal government, but also states via the 14th Amendment here. So not only is the government protecting you against the federal government, but because it's applied to the states as well, it's done so via the 14th Amendment. So example number one, let's take some questions to see how it would work here. Which constitutional amendment provides for the expansion of individual rights found in the Bill of Rights here? So which amendment would that be here? The 14th Amendment. Again, due process clause, it's usually given to the 14th Amendment. So usually the Bill of Rights, it'll only apply to the federal government, but if the due process clause is invoked, it's invoked through the states through the 14th Amendment. So this is actually the correct answer. The 15th Amendment, it gave the rights of rights of citizenship to blacks. And so that was not. The 19th Amendment gave women suffrage, women right to vote, so that is incorrect. The 23rd Amendment, it gave DC residents the right to vote in presidential elections. And the 28th Amendment, what is the 28th Amendment? Okay, if you said there is no 28th Amendment, you are correct. There is no such thing. There's only 27 amendments as of the time of this filming here. So the correct answer is the 14th Amendment. So the Bill of Rights, the expansion of individual rights, it provides not only a citizen from being protected from the federal government, but also from the states through the 14th Amendment, usually through the due process clause. So which two clauses dealing with religion are found in the First Amendment here? So which two clauses dealing with religion are found in the First Amendment? Is it the free exercise clause? Yes. Due process clause? No, that's usually it's found in the Fifth Amendment. and then via the 14th Amendment. Establishment Clause, yes, but not the Due Process Clause. Free exercise, yes, and Establishment Clause. C is the correct answer. Due process, no. Exclusionary, no. Exclusionary, no. Free exercise, yes. So again, the first two clauses are the Free Exercise Clause and the Establishment Clause. Okay, in Mapp versus Ohio. Okay, in Mapp versus Ohio, you have a situation. The Supreme Court ruled that evidence obtained without a search warrant could be excluded from trial in state courts. This finding upholds a right against unreasonable search and seizure found in what amendment? Okay, so let's take a look at these different amendments to see what freedoms are listed in these amendments. First Amendment, okay, you have the freedom of religion, you have the freedom of speech, you have the freedom of press, assembly, and petition. So that's none of these rights here. This is the right to bear arms. So that's also incorrect. It's not A, it's not B. The Third Amendment is against quartering soldiers. That's also incorrect. Fourth Amendment is unreasonable search and seizure. That is the correct answer. And again, the Fifth Amendment is you have rights as accused. If you could summarize that into a couple of different things. So this is incorrect. So the correct answer is D. The right against unreasonable search and seizure is found in the Fourth Amendment. And finally, example number 4. What are two constitutional guarantees? So what are two constitutional guarantees found in the Fifth Amendment? So let's just focus on two of the most basic ones. So right against self-incrimination. Self-incrimination. And so that can apply to a lot of different things. The idea that you don't have to testify. You don't have to testify against yourself. And Miranda rights, read to you after being arrested. So basically, police officers are required to say you have the right to remain silent, you have the right to an attorney. They're required to say this to anyone that they arrest for a crime. So self-incrimination kind of extends beyond the courtroom. Okay, another one has to do with double jeopardy. So again, if you're going to do free response, then you're going to put these in sentences. Again, for the purpose of time, I'm not writing them out. I'm just kind of writing bullet points here. Double jeopardy, if acquitted, you cannot be tried again, and also cannot be punished multiple times. So if you are acquitted of a crime, theoretically, if after a not guilty verdict is read, you proclaim, "Ha, I got away with it," technically, there's nothing that can be done. You've been found guilty, or you've been found not guilty, and you cannot therefore be tried for that same crime. Probably not the most recommendable action, as the court of public opinion would turn against you. And keep in mind, if there's monetary damages awarded, you could be sued in civil court. So you might not be put in prison, but you may owe tons of money to someone suing you. And if you say that you're guilty, that could be used as evidence against you. So again, these are the 5 freedoms found in the first portion of the Bill of Rights. So you have the freedom of religion, freedom of speech, freedom of press, assembly, petition. The Second Amendment is the freedom, the right to bear arms. Third Amendment is the right against quartering soldiers by the government. The Fourth Amendment is the right against unreasonable search and seizure. And the Fifth Amendment deals with the rights of the accused. Thank you for watching Educator.com.